Hello, everyone, and welcome to today's Lawpath webinar. My name is Ryan Tan, and we're going to be discussing how to protect your intellectual property, what you need to know. So we'll be joined by our resident expert in-house, Damon Murdoch. He'll be coming on shortly, and he'll be going through the presentation today on all things intellectual property. Now, if there's any questions from today's webinar, please pop them in the chat or the Q&A box, and we will attend to them towards the end of the presentation as well. So just while everyone's coming into the webinar, I'm just going to launch a quick poll. We want to understand a bit about your business and what your biggest focus is in 2022, so we can make these webinars very relatable and useful to you all. So I've just launched the poll. If you could take a moment or two to fill that out, that would be great. Now, we're going to have people from all industries coming into today's webinar. So a lot of people from, say, consulting, tech startups, e-commerce, people in the construction and the medical industries as well. So again, no matter what industry you're in, this webinar will be highly targeted and useful for you. And intellectual property is often the bedrock of contracts and your business as well, ensuring that you can protect it, especially when you're working with, say, employees or third-party vendors. Having the right documentation and contracts in place is very important. And definitely stick around towards the end of the webinar. We do have an exclusive webinar offer, which you will love if you're looking at intellectual property as well. So thanks to everyone for filling in that poll. Now, just on today's agenda, we're going to be going through a bit about Lawpath, a bit on Damon and introducing him, and then we'll go into what is intellectual property, what are the different types of intellectual property that exist in a business, and lastly, the importance of protecting your IP. Then we'll go into how Lawpath can help and some Q&A with Damon. We'll end off with our legal health check and how that can assist you as well. So just a bit about Lawpath and what we do. We provide smart, simple legal for small businesses, and we do this through our legal documents library, where you can create documents, manage compliance, and connect with lawyers on demand in one single platform. And over the last 8 years, we've helped over 300,000 businesses save over $100 million in legal fees. And we've also garnered 10,000 plus 5-star reviews on Trustpilot and Google as well. So we love helping small businesses. IP is one of the big topics that we help them out with, but all things business and commercial related is what we help out with as well. Now I'm going to introduce Damon. So for people on this call, especially those who are already on the legal advice plan, you're probably familiar with Damon, as well as our webinars. He's hosted a lot of them. He has 14 years of experience in an array of legal areas, and he's a 5-star rated lawyer here at Lawpath. So without further ado, I'll pass you over to Damon. Thanks, Damon.
Thank you very much, Ryan. How are we doing today, everybody? So today we're talking about intellectual property. You've probably heard of it. You might not know all the aspects of it. And so what we're going to try to do is give you a little bit of a update on intellectual property, a little bit of the nuances, and a little bit more information to inform you about how to protect it. So intellectual property, it's copyright, it's trademarks, it's trade secrets, it's confidential information, it's anything that's intangible. So when you think about your business and what kind of intellectual property you have, your price list, your client list, that's all intellectual property, but it falls into the category of copyright, which we'll talk about in a moment. If you talk about your business name, your brand, that goes into the trademarks. And sometimes your packaging, like the design, the look of the Omo bottle, that's going to be a design. So we'll look at that as well. And then there's obviously patents, which we'll just touch upon because generally speaking, lawyers don't necessarily deal with patents in terms of the registration of it. Those go to patent attorneys, which are different to lawyers. Those are individuals that have a science degree first and then has done a master's. And so if you were to get a patent done in chemical, you would get someone that has a chemical engineering degree and then register your patent in chemicals, or a computer science degree to register your patent in a computer program, for instance. Now, we have copyright, and we'll just break it down into the different types of intellectual property. So copyright is the one that most people have. It's automatic. It is created immediately, normally once you put it down on ink or on a computer. So that's your computer program, that's the website content, that's your logo itself, it's your brand, it's your slogan. All of those are copyright. And it's basically anything that's literary, artistic, or music. And in its expression of an idea, and that's what copyright is. And in Australia, you don't need to register it. It's just automatic. But I'll get into the difficulties with proof of ownership in a moment. The next one is trademark. That's your logo and your name and your slogan again. But that's where you actually can create a trademark that prohibits other people from using that exact name or that exact logo in the area that you are in. So I'll give a couple examples of that as well. And then we have how to protect them and what you can do to create that ownership if you haven't done it already. Now, one of the things that we do quite often is capital raising here. And the number one thing that when we do capital raising is the investors have a look to see whether the company actually owns the IP. And so I just wanted to touch upon this briefly, which is if you've ever got someone to develop a logo for you or your name or your stationery or draft content for you or help develop your software or whatever it might be, you want to make sure you have an agreement. And you want to get an agreement signed off from the very beginning when you just started your business so that you can prove ownership of everything once you go and do a capital raise or as you grow and sell your business. Because that's the number one sticking point oftentimes in due diligence when you're doing capital raising is that some small developer that did a very small portion of your software 5 years ago, you can't prove ownership of that. And that creates a risk or liability to the company in the event that that company becomes very successful. You might have a claim coming after you for that from that developer in the future saying that they own that copyright or they own that software. And then we have this moonlighting problem, which is if you're developing something while you're currently employed somewhere, then the question is well, is your old employer going to claim ownership of what you've just developed? And so it's really important that you have a look at your employment contract and make sure you're not creating something that your existing employer could claim against you. And the way you do that is generally you don't work on it during office hours. You don't work on it on the company computers. You don't use any of their confidential information to create what you're creating. And you don't use any of their trade secrets to create what you're creating. And that's one of the things that you need to be very careful of and maybe even keep a record of that so that in the future, if your existing employer says, wow, that's in direct competition to what we intended to do, you're able to prove that you didn't do it while you were employed using their resources. Now, copyright, as I mentioned, it's automatic. You don't register it anywhere. You don't register with IP Australia. It's just something that comes into existence and now you own it. So books, drawings, paintings, photographs, computer programs, so on, that's copyright. Generally, it's in written form. Now, even though you don't need to register it anywhere, if you ever wanted to sue for copyright infringement, one of the things that you need to prove is that you're the author or you have the rights to that copyright. So one of the things that you normally do is for all your employees, you have an intellectual property clause in your employment contract that says that any inventions, any intellectual property that comes into existence or written by any of your staff during their employment is automatically owned by the employer. So that when it does come time to prove ownership, if you have to go to court and you're suing someone that is infringing upon your software or your copyright generally, then you're able to show that your company, you incorporated your company employed this person wrote it, this person was the original author, who was an employee, And because they're employed and under an employment contract, then therefore this is owned by the company and we have a right to sue. If you don't have a document proving ownership, then you could fail when it comes to proving copyright ownership in an intellectual property dispute in court. So make sure you have it in writing, make sure you have documents to reflect that anything that a contractor makes, anything that a freelancer makes, anything that an employee makes for you and your company is owned by your company. Now, the Copyright Act is what governs the area of law regarding copyright. As I mentioned, it automatically is registered, it's automatically brought into existence, so you don't need to register anywhere. But one of the things that you need to consider is that there are different defenses available to people. So people can use copyright infringement for political opinion or for commentary for journalism or for humor and things like that. So that's why you'll see articles in the newspaper where they might be using someone else's logo, or they might be cutting and pasting an article or content from a website. They are copying it. They are infringing copyright when they cut and paste something and put it in the newspaper, but they're not breaching the Copyright Act because there's an automatic defense that they're allowed to use it for journalism. There are other defenses, which is called an innocent infringer defense as well. And that's where if someone uses your material, whatever it might be an image, it might be a film, it might be content on your website, whatever it might be, the innocent infringer claim is that they didn't know it was protected by copyright. And that's why normally you'll see on books and material and brochures and so on, a little C at the bottom, and it says all rights reserved and the name of the company. That is to assist in preventing someone from being able to claim the innocent infringer defense. So if you do have material that you want to protect and it can be easily replicated and copied, you probably want to have a little C on it, especially if it's in printed form. And then on that point, that's why you normally have website terms and conditions as well, where it says that everything on this website is owned by your company. So if someone cuts and pastes and steals it from you, then you can say, well, they visited our website, we had terms and conditions, these were the terms, they clearly knew that we owned it, and they've now infringed it, and therefore we're suing for copyright infringement, and they can't claim innocent infringer because of their terms were very clear. So when we look at what to consider, you want to make sure that you have everything in writing. As I mentioned, you want to have that little C if it's something that is that you really want to protect, recipes, things like that, books. You want to have a look at the duration of it. So sometimes you are a pen author or you use a fake name. Now there's different laws that apply to that. So one is it's 70 years if it's the author. But if you're Stephen King and you use a fake name to write another book, like Shawshank Redemption, I believe, then that copyright ownership won't last as long. And there's different laws around that. So just consider if you're going to use a fake name when you generate something, you might not have that protection that you think you have. And the last one is every country is different. And obviously we're only talking about Australia. And in America, you can actually register copyright. But that's beyond this presentation. But one of the things to consider is that if you're entering into a contract, you want to make sure that Australian law is the applicable law so you can protect your confidentiality. And confidential information is copyright. And so if someone was to steal your confidential information, it would normally be a breach of copyright and a breach of contract and a breach of confidentiality. Now, trademarks are a little bit different. A lot of people will go and they will get a business name registered, and then they think that that name is protected. It gives you no protection at all getting a business name. All a business name does is stop someone else from creating the identical name. So for instance, Lawpath has Lawpath as a business name. Anyone else can go and register Lawpath Solutions, Lawpath Enterprise, Lawpath Holdings, Lawpath, whatever, you name it. or Lawpath number 2 or no Lawpath number 3. A business name doesn't protect someone else from using the identical name with a slight deviation. What does protect your brand is a trademark. And a trademark is one that you file with IP Australia, and you file it in different classes. So if you're selling goods or services, you can protect it in a different class. If you've ever talked to me or seen my videos before, I always use this as an example. There is a footwear company called Barefoot. There's a beer company called Barefoot. Barefoot, the beer company, has registered their trademark in the alcoholic beverages class. Barefoot, the footwear, has lodged their trademark in the footwear class. That means that the Barefoot, the footwear, prevents anyone from using that word within the footwear industry. And the other one is anyone in the alcohol industry. So just by registering a trademark, you're not covered globally from anyone else using your brand. You're just protected in the class that you register your trademark in. So then some might say, well, let's just register it in all classes. Well, there's 45 of them. And if you register in every single one, that's fine. But anyone can then get your trademark removed if you can't prove you're using it in that industry. And that's what's called a non-use application. So if you are going to register your trademark, you might operate in several different industries. You might get a couple trademarks in different classes, but for every class you get it into, you need to use it to protect it. And you need to use it to save it, because anyone can file an application to have it removed. One of the things when we look at a trademark is whether it's unique and distinctive. Something that's purely descriptive isn't going to get across the line, and IP Australia will normally reject it. So if you call it your furniture warehouse, well, you're stopping anybody else in the furniture industry from using the words furniture warehouse. It's very unlikely IP Australia will allow that, because that's a description of what you're doing. It's not a specific word or unique distinctive word that identifies your business from others. So you need to have something that's fairly unique and not necessarily purely descriptive. You also wanted, when you do come up with your business name and your logo and your trademark, you want to make sure you have a look at IP Australia, and you can do a search on the IP Australia website for other trademarks that exists. And I always recommend just doing a Google review as well, and looking at the slight difference between the spelling and trying to find if there's anyone else out there who's trading under the exact same name. And if they are, rather than spending a lot of money on Google AdWords and Facebook marketing and brochures and so on, and then finding out someone else has the same name, and then they're sending you a cease and desist letter, you're better off starting right away with a unique brand, and one that you can build upon and know that you're protected and no one else is going to come after you and sue you later for infringing their trademark. Trade secrets are another thing that is protected. Formulas, manufacturing methods, things like that. It's also copyright. But I won't get into too much about trade secrets, other than they are a form of intellectual property. And some of the things about trade secrets that you want to make sure you do is it's all about confidentiality at the end of the day. So if you're going to talk to someone about your secret, you're going to want to get a confidentiality agreement, whether it's a non-disclosure agreement or a non-compete deed or something along those lines. And you don't want to be sharing the details to anyone until you have a proper formal contract signed off. So if you have a chemical compound of how to make the most amazing cleaning product, you don't want to be showing someone after you've signed a non-disclosure agreement the formula to create that. And the reason is that suing on a non-disclosure agreement is very difficult, and they're very hard to protect, because you have to somehow prove that they only discovered that because of the meeting that you held with them. And they can just simply say, well, they discovered it on their own. Whereas if you have a non-disclosure agreement, you talk high level about what it is, what the formula looks like from a high level, what it achieves, what the results are, and so on. And then you enter into an actual commercial arrangement where they agree to resell the product or manufacture the product. And in those circumstances, then you put a non-compete clause in, non-solicitation clause, restraint to trade, confidentiality. You put a bunch of different clauses in to protect you so that if they then go and use that formula, you can ride off of the more substantive commercial terms that you've negotiated. And you don't have to just simply rely upon a non-disclosure agreement. So high level, get a non-disclosure agreement. Don't share the absolute details until you've signed off on commercial terms. Now, there is something called an escrow agreement as well, where it is possible you can get a third party to hold that formula for you, but just Google escrow agreements. It's something that's often used in technology and when you're dealing with formulas and chemical compounds. Sorry. So we've talked about the NDA. Now, patents, as I mentioned, it's kind of confusing at the end of the day. You have, in America, you have attorneys, that's a lawyer like me. And in America, you also have attorneys, which are patent attorneys and trademark attorneys. A patent attorney and a trademark attorney is not a lawyer in Australia. They are someone that has a science degree. And if you're going to get a patent registered, you're going to someone that has a specific knowledge and a scientific degree to help you draft your patent. So as I mentioned, computer science degree will be a patent, or a computer science degree plus someone that is a patent attorney with a computer science degree will draft the patents for software. Someone that has a chemical engineering degree will draft a patent for chemical. Someone that has a mechanical engineering degree will draft the mechanical patent, and so on. So lawyers generally don't do patents at all. We get involved in enforcement of patents together with patent attorneys who can give advice on the specifics and the technical breaches of those patents. But if you are going to go and consider getting a patent, you'll need to talk to a patent attorney. It has to be patentable, which means it's got to be a new invention. It has to be innovative, and it has to be applicable in the industrial application. It can't just be a one-off where you're going to go and get something patented and then never tell anyone and never actually use it. But one of the most important things about a patent is that you don't disclose it before you go and register it. The filing of a patent is very similar to a trademark in the sense that IP Australia is the organization where you register your patents. And the process can be very long and grueling and fairly costly. And it depends on what kind of patent you're going to be getting, how long you want to be protected for. And oftentimes, if you're going to get a patent, you're normally going to go international with it as well. And so you're going to be wanting to get a patent internationally. Designs are, as I mentioned, it's like the old Omo bottle, it's the Lego brick, it's custom equipment that you install on vehicles, things like that. It's something that's innovative, but it normally has a shape or configuration or pattern and so on. So if you're designing a product, rather than getting a patent, you might be getting a design instead. But you still be covered by copyright, because when you draw your pattern, or when you draw, you might use a 3D drawing, CAD drawing software to draw your actual design. That is protected by copyright, but then if you register it as a design, you'll get further protection. The application process is also with IP Australia. And again, it gets a little bit more complex than a trademark registration. And there's different, so you can get a 5-year, 10-year, and so on. But that's essentially it in terms of intellectual property. It is a fairly quick presentation today, because normally when we get involved with intellectual property, we have a lot of questions. So what we'll do is we'll get into the questions in a moment, and I will pass it back to Ryan.
Perfect. Thank you so much, Damon, for going through that and giving us a high-level overview of what we need to know, especially in terms of protecting our intellectual property. Now, I can see that we have a lot of questions. There's a very high attendance rate and engagement here as well. So I'll just get straight into how Lawpath can help. Firstly, we have a contract management system for your business. So you can access all the templates and the legal templates that you need from all different areas of law, whether it be intellectual property documents around licensing, distribution, employment agreements, etc. We do have personalized workflows as well that can assist out with this process. So we do have 8 specific workflows around employment, setting up a family trust, and collecting a debt. But thirdly, and most importantly, booking in legal consultations. So if you do need to get contracts reviewed, whether they be IP specific documents or their other documents, or even if you want high level advice on, say, the trademark process, or just getting a general overview of the international trademark process, these are definitely topics that we can help out with the lawyers on the legal advice plan. So just on the plans itself, there are 3 different plans here. On the left, we have our essentials, which is the legal document templates. So right now we've grown the library to 365. Now it does include e-signature as well, and adding 3 different team members into the platform so you can share it with your staff. So that's the essentials plan. Now the legal advice plan is what Damon represents here at Lawpath. So you can get on-demand legal advice with Damon and our lawyers with unlimited 30-minute calls on all topics, business and commercial. We do also offer legal contract reviews up to 4 pages. So you can take most of the documents from the library and get them reviewed and select the pages that you need to ensure that you've done it properly and that you're compliant. So that's the legal advice plan. We do have an accelerator program, which is available under this plan. And one of the topics of the accelerator program is intellectual property itself. So one of the lawyers can sit down with you and do a holistic overview and a comprehensive scan of your business's IP, including trademarks. We can also prepare a free report for you to show you what you might have and what you might not have, and how we can assist with that process. And then just lastly, on the right, we have the legal and accounting advice plan. So this one includes everything from the essentials and legal advice, but it does include accounting calls with our accountants at Pop Business. So they're chartered accountants. They offer high-level advice on all things from, say, tax deductibility to paying yourself as a director, trust structures, and the like. So if you do find yourself needing accounting advice, this is a great plan for you. Perhaps you have an accountant already, and this could be great just to get a second opinion or to get some high-level advice, because a lot of accountants, some of them are chartered, some of them are not. So again, you can just get a second opinion. And then the ASIC and ATO agent service down the bottom, that's something that we offer for free on this plan. So if you need to make company changes as you grow, whether that's changing a director, changing a registered address, or making amendments with ASIC throughout the year, we do offer that service where we can elect to be your registered agent, and that is included in the plan. The accounting plan does have an accelerator program as well. So there are 6 different topics around group structuring, asset protection, going through tax deductibility, and also forecasting liabilities as they fall throughout the year, and budgeting cash flow to meet those. So today's exclusive webinar offer on the theme of intellectual property is a free trademark registration. So again, if you're looking to register a trademark in one class or multiple classes and you've been thinking about it and this is on your mind, we are offering this for free for webinar attendees. Now, this one normally costs $499 on the website, but for everyone here, you do get one for free. So again, you can secure the exclusive rights for your brand, logo, and safeguard your intellectual property. It gives you exclusive rights for 10 years. So this offer does allow you to register it within one class, and you'll be able to add the TM logo to your branding as well. So this one, to redeem it, if you are keen, please type yes into the chat or the Q&A box, and one of our team will give you a call after. But in order to get access to this one, you just need to sign up as a new customer to our legal advice or our accounting advice plan. If you're an existing customer and you upgrade from, say, essentials onto legal advice or legal advice onto legal advice and accounting, then you're also eligible for the free trademark registration, which is valid for this week only. So again, if you are interested, please key yes into the chat, and we will be in touch this afternoon after the webinar. So I'm just going to pass it back to Damon for the Q&A. Thanks, Damon.
Thank you for that. All right, well, let's get into your questions. So first one is, my company has been contracted to perform various admin tasks, and we have automated much of the job. The contract makes no mention of IP only. the task to be completed, who owns the code. So the general principle is if you do not have it in writing, whoever, except for employees, if you're a contractor, if you don't have it in writing, the person that brought it into existence owns it. There's no way to transfer intellectual property unless it's in writing. So if you've developed some intellectual property for someone else, they've paid you for it, you still have not transferred the ownership of that to the company that you were engaged by. Instead, you've given what's called an implied license, where you've clearly been paid to build something for them or to make something for them, and then they've paid you for it. So therefore, they have a right to use it, which is a license, but it doesn't mean that they actually own it. So you can't transfer ownership of intellectual property by implication. It needs to be in writing. How do you get a patent internationally? So that, again, that's to deal with the patent attorney, and you can contact a patent attorney to assist you with that. Lawpath has various patent attorneys who are who partners with Lawpath. So they generally will have a fixed fee, and they generally work with startups, so they are quite reasonably priced. In terms of trademark applications going internationally, I know that's not your question, but it's something that we get quite often. There is something called the Madrid Protocol, and that's where once you get a trademark registered in your host country, like Australia, then you can ride off of that application and lodge an application with the World Trade Organization to issue your patent internationally through the Madrid Protocol. And the date that your Australian patent or trademark was registered is the date that will apply, which is called the priority date, to all the other applications that go around the world. How much does going down the trademark route, I guess, or route cost? Well, as you saw there, is $4.99. That's inclusive of the $250 IP Australia application fee, I believe. Normally, it's around $800 for a lawyer plus the application. So, yeah, generally speaking, if you're looking to get a lawyer do the trademark for you, it's around $800 to $1,100 plus $250 application fee, which is called from the pick list. But if you want to customize the words, then it's normally $330, and that's per application in one class. Now, I think there's no other questions unless we've got some in the chat. So I'll just have a quick look at the chats. One of the questions is, what if I engage a developer to build an app for me on my instructions and design, and I paid them? Do you automatically own the rights? No. Likely you have a license to use it, but you don't own it. And you don't own it unless you have it in writing. And there's a bunch of case law on that as well. And it starts getting quite complicated when you start looking at the facts involved with that. But if you want to own something, you definitely need to put it in writing. Can a design architect process diagrams developed uniquely within technology create a registered or registerable for IP? So definitely, if you create, lots of case law around the development of a model home, the architectural layout of that home and the design of that home. It's normally done in a CAD drawing, but that home design is owned by the architect that developed those plans. And then they often go and license it to builders who then license it to homeowners to build in accordance with those plans. And there's copyright in those plans automatically. Whether there's a registerable one, probably not. If it's a home, it's probably not it's not patentable. And it might be, you might be able to register the design, but most of the time when you look at homes, for instance, it's normally copyright infringement because that is copyright. I'm keen to find out how tricky it is to get a formulation chemist to commit to a non-compete. If you're going to get someone to sign off on a document that says that they're not going to compete with you, it's normally what the outcome is going to be is, how do I know not to compete with you when I don't know what it actually is? So you would have to tell them, you know, I have created this soap, and this soap has this fragrance, and we're intending to use these as the key ingredients, but and that's it. But you're going to have to tell them a little bit for them to agree to non-compete. I've used a designer to develop my logo. I have a receipt for the work done. Is that enough to prove I'm an owner? No. If it's not in writing that you own it, then you don't own it. You can retrospectively get ownership of it, which is called an IP assignment deed. That's in the document library within the Lawpath platform, where it's a deed rather than an agreement. And I'll just explain that briefly. A contract or an agreement is an offer and acceptance, a meeting of minds, so you both understand what the agreement is about, and consideration. I'm giving up my time to develop your logo in exchange for you to pay me money. Now, a deed doesn't have consideration. It doesn't have the giving up of something for the benefit, for receiving a benefit. And so we normally, if someone's developed that logo in the past, there's no reason for them to now sign an agreement to agree that all that IP is owned by you, because there's no consideration flowing. They've already designed it, that you've already paid them. They're not getting any benefit by entering into this agreement. So the agreement fails on what we call want of consideration. It fails because there was no reason for them to sign it, and there was no benefit or detriment flowing between the parties. So instead, we enter into a deed, and a deed doesn't need that consideration. So that's just a legal technicality. But if you want to go back and get people to sign off on a document, it's not on an agreement, it's on a deed, because it's going back and there's no benefit for them to sign it. Will these slides be available after this webinar? Yes, and they'll be on YouTube as well. And I think that's about it. So I'll pass it back to Ryan. Thank you very much.
Thank you very much, Damon, for that. And thank you for everyone for sticking around. There is a bit more to cover in terms of questions around the trademark. So what this does include is that we have a DIY trademark tool on the website, so you can register this. Now what it does include is one trademark in one class. And this is a do-it-yourself tool. So that's what the free trademark is for. If you do jump on the plan, the legal advice or the accounting advice plan, you will get advice on trademarks, but this free trademark registration does not include the lawyer doing it for you. However, you can get advice generally around trademarks and the whole process as well. Now, again, if anyone has not yet typed in yes into the chat, please key it in now, and we will be in touch on how to redeem it. In order to redeem the free trademark as well, you need to complete a consultation with our lawyers. And as you can imagine, this does take some time to book in and get onboarded to the platform. So again, this offer is available for this week only. If you are keen, type yes, and we will be in touch. Thank you everyone for attending the webinar today. I'm just going to pop open a feedback poll as well. We want to gain a bit of feedback on how you found the webinar today and how we can improve it in the future. So if you could please take a moment to fill that in, that would be fantastic. But otherwise, thank you so much for attending the webinar today. I will leave the slides up as well. If there's any last minute questions or interest in the offer, again, key in yes, and we will reach out to you. But thank you so much for your time and have a great day.